Welcome to Trial Talk, insights from experienced New York trial attorney Michael Joseph.
Hello and welcome back to Trial Talk, insights from experienced New York trial attorney Michael Joseph. As a New York City trial lawyer with more than 20 years of experience, Michael has handled countless cases involving sidewalk and street hazards that injure everyday pedestrians. I'm Kevin Rosenquist, and today we're going to break down those common questions when someone trips, slips, or falls on a New York sidewalk. Who is actually responsible? Michael, good to see you.
Thank you. Thanks for having me.
We touched on this a little bit in the last episode with tourists. We're going to unpack it a little bit more. New York sidewalks are everywhere, but so are the cracks, the uneven slabs, the ice patches. What does the law say about who has to maintain them?
Well, I think there's a difference between whether you're in New York City or one of the outer boroughs and what type of defect it is. Snow and ice, no matter where you are, the building owner or the property owner has a responsibility to clear the sidewalk within a reasonable period of time. And it kind of depends. What we do to prove those kind of cases is obviously we get the weather reports, see when the last weather event was, when it last snowed, when it last rained, how long it has been since the storm ended, for example, and how much time they've had to clean up the snow and ice. On the other hand, potholes, defects, that depends on where you are. For example, in New York City, we have an administrative code that places the responsibility to maintain the sidewalks on the owners of commercial properties. It doesn't apply really to one or two family homes, but if you have an apartment building, if you have a commercial store, if you have an office building, or really any other kind of commercial property, the owner of the property is responsible to maintain the sidewalk up and to the curb. Now, a couple of exceptions. The city of New York is responsible for the tree wells, and the city of New York owns all the trees and owns all the curbs. So if you happen to step into a tree well that doesn't have the grate there and you get hurt, well, that's a city of New York problem. If you fall on the sidewalk next to no buildings, where there's a park or there's just not a building right there, that's a city of New York problem. If you step into a pothole in the street, that's a city of New York problem. If you step on a curb and the curb is missing, that's a New York City problem. However, if you step into either a pothole or you trip and fall on the sidewalk in front of, say, a business, that's the business and the business owner's fault. So it really depends on where you fall, what caused you to fall, and geographically where you are. Outside the counties, outside the city of New York, I would say, and like say Westchester, we don't really have necessarily these laws. So you'd have to really be able to show on most sidewalks that the municipality was at fault for not maintaining the sidewalk.
Getting back to the snow and ice, like you talked about, I believe you said a reasonable amount of time after a storm seems a little vague. How does that usually kind of play out?
Well, I think generally they say 12 hours, but I think it depends also when the storm stops. So if it stops at 2 a.m, you fall at 7 or 6:30 in the morning, that's not necessarily a reasonable time.
Yeah.
If, however, the storm stops at 7 a.m, you get hurt at 3 p.m., you had a reasonable time during business hours. You should have cleaned it up. So it's a little bit of a soft standard for a reason. Generally, if you haven't cleaned it in 12 hours, that's really bad. That's a violation of certain statutes.
Mm-hmm.
But certainly, and what you see also is sometimes freeze-refreeze events. Like a storm will stop, they'll clear it, but then they just kind of they pile the snow alongside the curb, but then it melts and then it freezes again. So that there's sometimes secondary weather effects where they're also supposed to look out for. They're supposed to sand, they're supposed to salt, do what they can to make the premises really safe.
So you might have touched on this before, but I want to make sure I ask this question with the sidewalks. Obviously, we just talked about snow and ice, but if there's actual damage to the sidewalk itself, uneven pieces or just huge cracks or something like that, is it the property owner's responsibility to make sure that the city fixes that? Because that's not the property owner's responsibility to actually fix that, is it?
Well, in New York City, it is.
Oh, it is.
New York
Okay.
City actually passed a law that the property owner themselves, not one and two family homes, but commercial property owners, apartment buildings, businesses, they are actually responsible to maintain the sidewalk up and to the curb, and they're responsible for what happens on the sidewalk up to the curb.
Okay, so everything, even just general wear and tear.
General wear and tear. All we have to show is that they knew or should have known that the property was dangerous, that there was a crack there was a pothole there, that someone could get hurt. And once you show they've known about it or should have known about it, you can win your case. City of New York's a little different. If you have a case against the City of New York, say, for example, you're walking in Queens in front of a one-family home, that law doesn't apply to the one-family homeowner. So now you have to sue the city or make a claim against the city. So if you have to sue the city, you have to show that either the City of New York had prior written notice of the defect, or they caused and created the defect. Cause and create is, means, like, for example, they did bad construction. They opened the sidewalk and they didn't properly close it. They have a tree whose roots are lifting up the sidewalk and they didn't properly address that. So there's a number of ways to prove cause and create. In terms of prior written notice, one of the most common things we do is we search certain indexes that document everybody else who's made claims against the City of New York by location, so we can see if prior claims have been made for that same location. In terms of just a property owner, a pothole, a uneven or broken sidewalk, we can look at the Google Maps and look at the street views and see how long it's been there, and go back. And that's the very easy way to prove that they knew or should have known about it.
Mm-hmm.
We also look at other lawsuits. For example, in a recent case, this wasn't a sidewalk case, but we had a dangerous condition on the stairs inside a restaurant, and we found 3 months prior to our client, someone else got hurt for the exact same reasons.
Mm-hmm.
So they certainly were on notice from the first accident.
Okay, so we've gone over a couple different scenarios of whether it's the city or a building owner or whatnot. When you make the decision that you're going to sue, you've got a lawyer, you're going to sue. How does that process work versus between the city versus a private entity?
With a private entity, we can certainly sometimes just write a demand letter, to let them know that there's been an injury, and sometimes their insurance company will get involved. If they ignore us, then we file a summons and complaint, and we go forward with a discovery in like a regular case. With the City of New York, you have to file a notice of claim within 90 days of the accident. Then they go for what's called a 50H hearing pursuant to General Municipal Law 50. And they're all virtual now. So basically, we do these people all over the country who get hurt in New York, including a lot of New Yorkers. It's on a laptop, and it's usually on either Zoom or Teams. And really, a defense lawyer just asks you questions, and everything you say gets taken down. They ask you questions about what happened, how it happened, where it happened, etc., what your injuries are. And after that, then you can file a summons and complaint. Generally, for a claim against the City of New York, you have to be able to kind of show going into the case, or know you're going to be able to show that either they had prior written notice or that they caused and created the defect, which means if it's a significant injury, we'll get architects or engineers involved to look at pictures and see what work was done, and maybe do Department of Transit Highway searches to see who's done what work in the area, who's opened the street, who's closed the street, who's opened the sidewalk, what utilities have opened the sidewalk recently, especially if it looks like it wasn't properly closed and sealed. And then once you do the 50H hearing, then you can file a lawsuit. But with a case against the city, you only have a year and 90 days. But in a case against a general landowner, you have 3 years to file a lawsuit.
Okay.
Those are some of the procedural nuances.
Yeah, definitely some nuances there. What about when construction plays a part in it? Well, where there's a construction zone, maybe the pavement's been torn up, temporarily patched. Does that change the who's at fault?
Well, yeah, because it doesn't necessarily change the fault, but I would say you have additional parties who may be at fault, because the building owner always has responsibility to maintain the sidewalk in a good condition. However, where a contractor is actively in control of the job site, they also have a responsibility to make sure the sidewalk stays maintained in a good condition and safe for pedestrians. And we've seen plenty of cases where, for example, there's demolition, there's an empty lot, heavy machinery is being brought across the sidewalk, and it just tears it up.
Mm-hmm.
In those kind of cases, they have a responsibility to section off the sidewalk or put barricades up, redirect people to a safe area, and ultimately repair the sidewalk. If they leave a sidewalk broken, certainly a contractor who's done work in the area can be sued.
We talked a little bit about this in our last episode, but I want to bring it up again just in case anybody missed that one. Shared fault, comparative fault. If someone was distracted, didn't see the defect, how does that all work?
Well, for example, there's 100% fault, and generally a jury at the end of the case has to allocate how much fault the the building owner or property owner or a contractor had, and how much the injured party had. Could the injured party have been more careful in avoiding the accident? It's not really a defense so much as it reduces the damages. So, for example, if I just threw out a number, $100,000, if you were entitled to $100,000 for an injury, but you were 20% at fault, you would eat the 20%, so really you would get 80,000. So typically what happens is where there's comparative fault, it gets worked into settlement negotiations, and ultimately if we can't come to an agreement and come to a settlement or resolution, a jury's going to decide.
That seems difficult to figure out the percentage. How is that calculated, or is it just depend on the situation?
Well, I think it depends on the situation. It also depends on the judge or the jury, because if you try the same case in front of 10 different juries, you could get 10 different results.
Yeah. That's got to be tough for setting expectations.
Of course. A lot of times it is like flying in the dark, but if you have to kind of figure out if you have liability, and it could be between 50 to 80% that you use those parameters, and you kind of realize if you try 10 different times, you're going to get 10 different verdicts that the other side's probably either 50% fault, 60% fault, 80% of fault, 90% of fault, and you kind of just can figure out a rough number to take a reduction off of. Mm-hmm. Usually an average, say, for example, of what you think would happen.
Do you end up having to fight against the city often?
All the time.
Yeah.
as well as the lawyers for most of the insurance companies in New York. We have a busy practice, so yeah. We litigate against everyone.
I was just curious. You feel like the city should be on top of that. I know it's obviously a manpower thing, or what have you. But is it something that's getting better? Is it getting worse? Is it just something that is how New York City sidewalks in general, are they pretty bad, or are they generally okay?
Well, I think it depends on where you are, where you go. Certainly, you'll probably find better sidewalks for the most part in New York City, in Manhattan, than you would say in Queens or the Bronx or Brooklyn. But certainly where you have landlords who don't want to spend money on maintenance, you can have dangerous conditions.
Mm-hmm. When it comes to apartment buildings, maybe not even a big apartment building, but more the 2-flat, 3-flat style, where it's kind of a home on a street. Does the person who's renting in New York have any responsibility?
Generally, depends on the lease. A person who's renting to live usually doesn't have responsibility. Whoever owns the structure does. However, if you have a lease, and if you're a store owner, for example, and you have the storefront, and the storefront's on a sidewalk, you definitely then do have some responsibility. Certainly, especially a lot of leases will put the responsibility on the store owner, for example, to be responsible for snow removal, mm-hmm. for ice removal, and to maintain any defects in the sidewalk. So generally, we would present a claim certainly against the owner of the building, but any storefront businesses also.
And then as far as like a private, you said for a private, for a residence, for someone who's renting a residence, that they do not have a responsibility to keep the sidewalk safe.
In general, no, unless the lease specifically puts that responsibility on them.
Okay.
But even still, under the administrative code, for defects in a sidewalk, at least 1 or 2 family home owners or tenants can't be sued. It's more for bigger guys.
Okay. What else would you say is something that people get wrong about this process? Because it sounds like it can be pretty confusing as to who is at fault. Do people, what do they do wrong?
I think what most people would do wrong, or what would actually cause us potentially to even reject a case, is doing nothing for too long. If they don't have any evidence of what the condition was. Now, if you come to me 6 months after the accident, it's a sidewalk defect, it may still be more or less in the same condition. But for example, if you didn't take pictures of ice, if you didn't take pictures of, nowadays everyone's on their phone constantly. Yeah. So we get more and more videos of things that have just happened or have happened, than we used to. But everyone's on their phone. So if you do nothing, if you don't take pictures of it, if you don't report it, if you don't get medical treatment, it's kind of hard for people to if there's no paper record, or video record, it's kind of hard for people to believe it happened. So I would say that's really the biggest obstacle people have, is just doing nothing, not reporting it, going home, and then 2 weeks later deciding, they're in pain, they should have sued.
How quickly should they get in touch with you? I mean, what's the best case scenario? Is it just ASAP, or is there a certain timeline?
Well, I think it certainly depends on the case, but certainly if you're full on the city, if you fall on a sidewalk and potentially you may have a case against the city, within 90 days.
Mhm.
But I think it's also the question is, so if you have an injury, did you get medical treatment? Did you report the history? Because at some point, adjusters and insurance people and city attorneys or defense attorneys are going to look through the hospital record and say, okay, what did you say happened when you went in? So I think you have to, if you've gone to the questions, did you go to the hospital? Did you go to the doctor? We have to look through the medical records, see what you told them happened, make sure everything's consistent. Did you report it to the police? Did you take pictures or videos? So all those things kind of have to be in place for a suit to be really, or a case to be really successful.
If someone falls in front of a store, in front of even a government building or anything like that, should they always go in if they can and let the business or entity know?
Well, I think you should definitely take pictures first, but yeah, you should certainly let them know that you fell so that they report it to their insurance company. If the building is closed, I mean, you may want to hire an attorney right away so that we can then demand that they preserve any surveillance video. And if they don't preserve it, we can always say, hey, you didn't preserve this video because you knew you were wrong. You knew what that video would show and you let it disappear for a reason. So I think that's one of the advantages of why you do want to speak to an attorney sooner rather than later if you had a trip and fall accident, so we can get a letter of rep out and just demand they preserve the insurance, any surveillance they may have, so it doesn't
Mhm.
disappear.
Yeah, I feel like it's harder to make that claim these days, especially with cloud and all that stuff. Like back in the day, video was very temperamental. I remember dealing with that. Nowadays, it's probably a little harder to stand on that.
Well, video tends to disappear when it's bad for somebody.
Yeah, that's
So
true. That's true. All right. Well, that wraps up today's episode of Trial Talk. Insights from experienced New York trial attorney Michael Joseph. If you've been injured because of a dangerous sidewalk or street condition, visit newyorktriallawyers.org to learn more about your rights and how Michael can help. Thank you for listening. Don't forget to subscribe, leave us a review. We always appreciate it. Michael, always appreciate your time. Thanks so much.
thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.